Okay, great. So thank you everyone for joining today. We have our exciting event today, a virtual event sponsored by I-Corps at Rutgers, from research to patent, idea to innovation, the people and processes supporting innovators. And we have an exciting agenda for you today. Thank you all for joining. I'm Mark de Guzman. I'm the program manager of the Rutgers I-Corps site, and excited to help introduce this great panel. Connie Wu, from Rutgers Libraries, Dan Benderly from Innovation Ventures, and Dunbar Birnie, who's the PI of the Rutgers I-Corps Site Award. And so here's a quick overview of the agenda we'll be doing today. I'm going to do a quick little commercial about I-Corps. Then Dan will introduce Innovation Ventures and talk about Rutgers owned IP. Dunbar will talk about student IP, and then Connie will go into the intellectual property basics. They'll discuss about how to protect your IP and give some drop some resources for patent searching in the chat, and then we'll follow up with Q&A and a wrap up of upcoming events. Okay, we will have, if you have questions in the chat, make sure you, if you have any questions, you can put it in the chat. We'll try to answer them later on. But for now, I just want to introduce the idea about I-Corps, the program, I-Corps at Rutgers, driving innovation through customer discovery. We've been running this I-Corps site program for about since 2018, and it's a cohort-based program funded by the National Science Foundation, really getting teams to think about not just the research, not the science of the research, but how to develop customer feedback before building and launching the product. Really about getting out of the building and meeting with potential customers. That way they don't build something that people don't want. They build something what people are looking for. And so this program is about a 5-week program where we get trained in business concepts. You do 25 customer discovery interviews. You get reimbursements of up to $2,500 for customer discovery activities, which include virtual conferences, professional organizations, since travel has been kind of hampered due to the COVID restrictions. But I think that might open up as things start to open up. So this $2,500 could be used for travel if Rutgers is able to open up travel restrictions. And we use a specialized software to track the interviews and what you learn from these interviews. And really, we want to connect you to the resources available in the innovation ecosystem. And ultimately, you get access to a national network of innovators all across the country, whether you need funding, resources, mentorship. So the website is icorps.rutgers.edu. Yeah, 1 second. I have to, hold on. I have to, just 1 second. Oh, I just have to, Dan, I'm going to make you a co-host. I forgot to do that. 1 second. Co-host. Yes. Connie too. Okay, sorry, apologies. So you can be the mute police. Thank you. Great. And then we also have, so that's for teams, right, who have an innovation and want to figure out the commercial potential of their innovation. We recently launched a I-Corps fellowship program, which promotes diversity and inclusion for underrepresented groups to participate. We offer a stipend for this educational experience to learn about innovation and commercialization processes at Rutgers. And there's 2 types. You could be a team member where you're matched with a team based on your background, your interests, and your skills and your network to make sure it complements the team, where you really are supposed to help with customer discovery activities in any meaningful way that you can. As long as you can contribute in a meaningful way, that's great. The other way is the cohort and ecosystem fellow, where you work more closely with the teaching team to work with them and running the cohort and really seeing what happens behind the scenes and how we help guide these teams forward. And it is a 3-step application process. So the application is a Qualtrics survey where we find a little bit about you and your interests. Maybe you have leadership experience you want to talk about there, and your focus or your maybe experience or interest in innovation. We'll do an interview with you to get to know you better, and then hopefully if you're selected, we will match you with a team. There's more information about this on the I-Corps fellowship website, which I think Dan will put in the chat. And so applications are open now. We have a deadline for June 4th for the summer cohort. If you're a team with an innovation, usually a faculty researcher or a student from a capstone course who wants to really bring it forward, go to icore.rutgers.edu to do the application. The cohort will run from early July until mid-August. Maybe you're not ready for the summer, that's fine. You can always apply in the fall or spring. And we are, even though it's a Rutgers iCore site program, we are open to other institutions in the region, especially those from Hispanic serving institutions or minority serving institutions, HBCUs and tribal colleges. And so the applications for the fellowship is open as well. Feel free to email the iCore at, it's actually at research.rutgers.edu. And you can always email me. My email there is m.diguzman@rutgers.edu. Okay. So thank you for this. I will now turn it over to Dan, who will just introduce a little bit about himself and Innovation Ventures.
Thanks, Mark. So my name is Dan Benderly. You can see my pre-COVID picture there. I'm part of the Innovation Ventures team. Briefly, and I'm not going to spend a lot of time because we really want to get to Connie. Talk about the patenting. My background is electrical engineering, and then with an MBA, 25 years in industry, bringing really innovations to market in both startups and large companies. Can you go to the next slide, please, Mark? So our mission at Innovation Ventures is to partner with the Rutgers community to encourage deliberate innovation. And that means deliberate innovation means innovation that's geared towards practical applications in the outside world. Protect and leverage Rutgers intellectual property, foster collaboration with industry, and enable entrepreneurship. And it's really in this rubric that I'm both responsible for licensing and patenting and protecting within the office, and here with the iCore team, helping teach these entrepreneurship and commercialization skills. And today we'll mostly be talking about that protect and leverage piece. The protect is what you're going to be learning about in terms of patenting. What we do in our office, we will take disclosures from you guys, some university-owned innovations. We will evaluate it from both a technical, patenting, commercialization perspective. We will go through the patenting process with you, as well as the commercialization process, and get it out into the real world, either through a license to an existing company, or many of our PIs are looking to do startups. Can you go to the next slide, please? Very briefly, talk about what is university owned. The university has an IP policy, and it basically says that if you've done it in the course of your employment at Rutgers, right, faculty and staff, it is owned by the university. And that is very typical both in academia and in the outside world. And I'll talk a little bit later what's different in academia versus industry. So the university pays for patenting costs and fees. When we do an evaluation and we decide that it's worth protecting it, we will pay for all of those costs. We will market, find potential licensees, negotiate those license agreements. We will administer those license agreements. So we'll collect the revenues, we'll enforce the terms of the agreements, and all of the things that that you guys as the faculty and staff of the university are probably not all that interested in doing, all the administrative part. The licensing income is distributed, and this is where it's different than an industry, because in an industry, the inventor usually gets, if anything, they'll get a small bonus, $500, $1,000. I've sometimes heard, $10,000 on a really successful invention. In a university setting, the inventor is getting 30 to 35% of the of any revenues that come into the university is distributed to the inventor. The Innovation Ventures, we get a piece of it to pay for our expenses, as does the inventor school, chancellor, and department. So the revenues that come from these inventions are really recycled back into the innovators, the innovator himself or herself, and their infrastructure and their labs that built that. Dunbar, you're going to talk about the student IP?
Sure, yeah, so I'm Dunbar Birnie in the School of Engineering, and I'm actually a big fan of patents and promoting student innovation. And so often the question comes up, does who owns this, the intellectual property that come up in capstone design or some kinds of innovation classes. And so in fact, in classwork, students have ownership of ideas that they come up with in labs or in capstone design projects and so forth. There are some caveats to that. If you've been hired by the university to do research in a lab, then you fall under the staff category, and those inventions would be owned by Rutgers. If you're working in collaboration with a professor, then that would be jointly owned by the university as well. But what's really good is that places like the makerspaces are available to everyone and are provided as an educational area. So makerspaces are fair game for student innovation, and you maintain your IP rights by developing those ideas in makerspaces. So there's more at that link, the specific wording, and contact in Dan's office if there were any questions about what's covered and what's not. That's it.
Great. And so now I want to have give the floor to Connie Wu, our engineering and patent information specialist from Rutgers Libraries. So thank you, Connie. And thanks, Dan and Dunbar, for the great information. Dunbar, maybe you want to put your email in the chat as well if anyone has questions about student IP. Connie, you're on mute, sorry. Connie, you're on mute. Let me see. Connie, we can't hear you. I'm going to ask you to unmute.
Mute myself. Okay.
There you go.
Can you hear me now?
Yes.
Okay, I'm sorry. Good morning, everyone. It is nice to meet you online. You just learned about university IV office and also the patent policies. So now let's talk about how to create a patent from research. You can see my name is Connie Wu. Before that, I do a little commercial. USPTO has 83 patent and trademarks resources centers in the United States. Rutgers University has one of them on Bush campus. So I'm the representative for that particular center. So in the future, any one of you need any assistance about patents and trademarks, please make an appointment with me. Okay, because patent is part of intellectual property, and also we call IP. So I would like to start with a few minutes, talk about intellectual property first. Okay, next screen. Next slide. Mark. Yes.
This one in
okay.
Intellectual.
Yeah. What is intellectual property? Intellectual property refers to creation of the mind. According to WIPO, which is the World Intellectual Property Organization, intellectual property is divided into two categories. Category 1, industry property, which includes inventions, that's its patents, trademarks, industry designs, and trade secret. And another category is copyright. Because we don't have enough time to talk anything in details, so I can only go very quickly about this basic introduction. Next slide. When people talking about intellectual property, everybody think about which is a legal matter. It's something to do with lawyers, something to do with legal things. But actually, the intellectual property covers at least 3 areas: legal, technique, and the business areas. Because all the intellectual properties documentation, like patents, trademarks, and copyright, consider legal document and also involved with a lot of litigation. Of course, it's a part of a legal area. However, according to statistics, 94% of information disclosed in patent have never disclosed in papers and also books. So patents is wonderful literature for technical information. And also when we're talking about today's business, we largely talking about intangible asset, because many companies nowadays has a wonderful patent portfolio and trademarks and copyright portfolio, which become their business asset. And when we consider merge and acquisition, we need to take into all this IP portfolio into consideration. So we have to see that the field of IP covers all three areas, not just the legal areas. Next slide. There's a 4 types of IP: copyright, trademarks, trade secrets, and patents. When we're talking about copyright, copyright issued by the Library of Congress. However, trademarks and patents are issued by USPTO, United States Patent Trademarks Office. So if you didn't register with your copyright, you still be able to write this C with a circle on your publication and claim you have copyright. But you cannot do that for trademarks, because the TM, that trademarks, you have to register with the United States Patent Trademarks Office to get your trademarks. And trade secrets is a negotiation up to agreement between 2, maybe 3 parties, and based on the state laws, right? And the patents, again, also need to be exempt and issued by USPTO. Next slide. Next slide, yes. Okay, in front of you is a little desk here. You can look at, you can see almost everything on this desk has a patent, from monitor to phone to like hole puncher and also speakers, everything has a patent. So you have to see that majority products in today's market, in your daily life, are patented by someone at a certain time. Next screen. So what is a patent? Most important thing here is a property right. The property right is to the inventors issued by the USPTO for US patents. So patent is not like paper and books. You know, you have the paper, you have books, you have copyright, right? However, the patent, you have the property right to exclusive others from making the invention, using the invention, and offering for sale or selling the invention in the United States. Here's the keywords: for a limited time. You cannot say, I can have my property right forever. It's based on different type of the patent. You get certain years protection. Next slide. So before we think about to apply for patent, we need to understand what can be patentable. Basically, the 4 category, 4 type of things can be patentable. Number 1, a process or method. The process method producing a useful, very important, useful and a tangible result. Okay, so this process, we can talking about engineering procedures, investment strategy, and computer software, or even a processing to conduct e-commerce on the internet. Give you an example, like Amazon has a 2-click, that particular one, starting business method patent. Okay, number 2 is a machine. Okay, no matter what kind of machine, copyright, photocopies, cars, air conditions, everything, a machine, and which can be patented. And number 3 is a product, a device. Okay, also in legal term called an article of manufacture, you know, like tires, hand tools, everything which as long as you have a device and products can be patented. And the last one is number 4, composition of matter, which most is like a formula. It's like a materials, chemical composition, drugs, soaps, and this kind of thing all can be patented. However, in today's world, very few patents or inventions are based on like a breakthrough patents. Like Edison's time, he's start from the scratch, nothing else. He has his own patents. Today's patent mostly based on improvement of previous invention and the previous patent. So today's patent will get improvement for this process, machine, and product, and also composition of matter. Okay, next slide. Okay, now we need to understand what cannot be patented. A lot of people said that they have a great idea, sounds marvelous, they want to get a patent. But before that, we need to understand the following things cannot be patented. Number 1, laws of nature, like motion, like ideal gas laws, those kind of things cannot be patented. And then number 2, physical phenomena, which also called nature phenomena, like lighting and the sound, those kind of things cannot be patented. And also like books and dramatic musical and artistic works can only be protected by copyright, not by patent, okay? And also inventions which are not useful, because in the next few slides, we were talking about what is the requirement for a patent. Number 1 is useful, has to be useful. If it's not useful, you cannot get invention. And some invention may be useful to do something, but because the invention is offensive to the public, still cannot get patent. For example, if somebody create a machine to how to kill a person, which is offensive, which is totally against, so will not get patent for this purpose. Now go back to number 3, abstract ideas. We're talking about Einstein. Before become scientist, Einstein is a patent examiner. And after that, he become an inventor for a patent about refrigerate. So he was a wonderful inventor. However, his greatest contribution is about his theory. But because his theory is abstract idea, so he can never get a patent for his theory. So like mathematics formulas cannot get a patent. So in the next slide, Dan will share with you when we consider about the software, which is somehow in some way coding could be abstract, but in other area also can be patentable. So then we'll discuss you more about software patentability. So next slide.
Dan, sorry, mute.
That's the best phrase of 2020, 2021.
Yeah.
You're on mute. So I'm going to try to be relatively brief on this question of patenting software. We could spend an entire hour talking about it, and actually we will. There's going to be a session in the fall that Connie is holding in conjunction with the USPTO that actually will be talking about software patenting. So if you want more, wait until then. It has a long history, and it's kind of gone, the pendulum has swung back and forth. I'll tell you what the kind of current state is. This was guidance that was issued in 2019 by the US Patent Office. Actually, before I go into it, let me talk a little bit about difference between copyright and patenting, because all software, right, code that you write is automatically protected by copyright. The difference between copyright and a patent, copyright will protect the expression of an idea. A patent protects the idea itself. And that's really what the difference is between them, and why a patent can be more valuable, because it's protecting the idea in multiple ways of doing it. But we kind of talked about how abstract ideas are not patentable, and they give examples in this guidance of what are considered abstract ideas: mathematical concepts, methods of organizing human activities, mental processes, and that's kind of vague. It's kind of things that can be done in the head, and it's not necessarily things that can be done efficiently in the head. It's like long division, for example, would be a mental process. It's something that can be done in your mind if your mind is powerful enough. So they go through this analysis, and then the first thing they ask is, does this claim, and it's done on a claim by claim basis. So if you think about a patent, there are a number of claims. You look at it on a claim by claim basis. And say, does the claim recite this abstract idea, law of nature, natural phenomena? And if the answer is no, then you're good, right? You just go down the other path. If the answer is yes, it does, it then goes and says, does it recite additional elements that integrate into a practical application? And what does that mean? So I use the example of long division, right? So long division itself is a mathematical formula, mathematical algorithm, and is not necessarily, it's not patentable. But if somebody came up with some unique new way of applying long division to get a rocket to the moon, right, that nobody had ever thought of before, I don't know, maybe you took that and you take some interim step there and do something with it, and it's a better way of getting to the moon, then that would be integrated into a practical application. And that is how many of the software patents are now granted. By taking this algorithm, a lot of AI is granted that way because you're not claiming the artificial intelligence or machine learning algorithms themselves, but you're claiming applying those algorithms to solve a specific problem. So that's the way to think about kind of patenting in the software realm. But I want to point out that this is guidance that was given by the US Patent Office and has not yet been tested in the courts. So this is still a very uncertain area. The courts have said in different areas that the USPTO guidance is not binding on them. They don't consider that to be necessarily what the law is. So we're in a bit of a gray area, but this is how the Patent Office is looking at granting patents in the software area. And it's become a bit easier since this guidance has been issued to get patents through the office. Thanks. You go to the next slide, Mark.
Thank you, Dan. Okay, now let's go back to about the patents. Again, because we don't have enough time, so I will go very quickly. So when you apply for a patent, you need to understand what is the requirement for a patent. And US PTOs, examiners, what they are looking into application to see if you can get a patent. These three requirements as a test by examiners, your application has to meet these three areas requirement. Number one, utility, which also called usefulness, which I mean, as I mentioned before, no matter what you come up, wonderful idea has to be useful, has a useful purpose, and also can be operative. If you have a great idea, but it's no use for purpose, you cannot get a patent. So number one requirement is usefulness. Number two, novelty, which means novelty. Novelty here is very important in the patent examination, because examiner needs to look into that to see your invention was not disclosed or used by others, including yourself in this country, or patented or in our print publications in this and in any other foreign countries. How do you say that? Means that before you apply for patent, before you send two applications, you cannot disclose your information. Go to a conference to present your paper, to publish in an article, because that one become evidence against your novelty, because 30% of the time the examiners in the patent office is doing the database search. Entire world, all the database to find out if you ever or somebody already had this invention or this patent before you. So novelty is very important also in the requirement for a patent. And last one is non-obviousness. What does it mean? That because majority patent is coming from improvement based on previous or others' invention. So the examiner will look at your invention to see a person who have ordinary skill in the area of technology related to your application who cannot come up with that idea. So that idea is pretty unique from you. So these are 3 tests you need to be meet for application to get a patent. Next one. Next slide. Okay, in United States, we have 3 types of the patents. Number 1, utility. Probably we call utility in most countries in this world, they call invention patent. We call utility patent. This is including new and useful. Again, new and useful. New means novelty, and useful process, machine, a product, device, or composition of a matter. And this is like everything you can see here, bicycles and the cars, air conditions, whatever utility. In United States, majority patent applied in the United States Patent and Trademark Office are utility patent. Okay, the number 2 types is a design patent. It's how an invention looks. It's about the looks of invention. Use example for iPhone. iPhone has so many design patents because Steve Jobs is crazy about looks. So he applied many, many design patents about iPhone. Okay, that's the design patents. And also only in the United States, we have plant patents. And most other countries don't have plant patents. The plant patents is a new variety of plants. Give an example, roses has thousand patents because there's 1,000 different kinds of roses. And Rutgers Cook campus also own a lot of plant patents, like Jersey tomatoes and new grass from New Jersey. This is about plant patents. So we have 3 types of US patents. Next. As I mentioned before, a patent protect for certain period of time. So here is the terms of the patents. Utility patent is 20 years from the filing date. If you apply for a patent this year, but you didn't get the patent until 5 years after, your utility patent protection starting from this year's, not from 5 years after. So 20 years from the filing date. However, design patent, you get 14 years protection from patent was issued. After you get your patent, you get 14 years for design patents. And the plant patent is similar to utility patent, 20 years from the filing date. So after 20 years, after 14 years, your patent, your invention become public knowledge. Everybody can use it without paying you. So protection is only within these years. Next slide. When we apply for patent, there's 2 kinds of applications. Okay, one is called provisional. The other one called a non-provisional. Actually, before 2004, in United States, we only have 1 application, which is a non-provisional. Also means a formal patent applications. From the date you are filing for a patent, you get 20 years of patent protection. Then your patent need to have claims. I mean, your application need claims to do the patent. Then also need to be examined by the USPTO. But non-provisional application is very, very expensive. Average speaking is between like $3,000 to $10,000, more than to $10,000 for 1 application. Quite expensive, right? So after 2004, USPTO come up with provisional application. This is wonderful for nonprofit organizations and wonderful for small business and individual inventors like students and some people, and also for people who are apply for provisional application. Actually, it's before you apply for formal application. You get 1 year protection, just 1 year. So within the 1 year, up to 1 year, you need to apply for non-provisional application. Otherwise, this provisional application is missed without existing in this world, right? So you filed for the filing date priority, which is very important. We have to talk about in the future because there's a lot of legal matter here, right? But the good thing about provisional, you don't need to have a claims. And at this point, until year after, you can get your claims. And you don't get your examination, so it's not real patent. It's just something called patent pending. But this one only allowed for utility patent, not for design patent. Beauty of the provisional patent application is very, very cheap. Filing fee is between $125 to $250. But if you are a student, if your salary under $140K, the filing fee could be under $100. So for that $100, you establish your application, then you can start to do a lot of things after. So go to next slide. Okay, so why it's good we do the professional patent application first? Number one, you establish an early filing date, because for similar invention in this world, many people can do the same thing at the same time. If you establish your early filing date, you get your patent right. Okay, first to file, okay? And also you can delay your filing cost. As I mentioned before, very expensive to file, to apply for non-provisional application. So you can delay this filing date to the later date. And also during this 1 year, you can go to the companies looking for market. Some company may want to have your provisional application and they pay you, you can sign your right to the company, then they can pay everything in the future. Okay, and also, but one thing you have to be careful, you don't just send in your ideas. You should have enough detailed information and to show to the USPTO that you are going to have claims soon in 1 year, and then you have all this ready to get a formal application. So that is very important. You have enough details to support your claims. Okay, and good thing is that you can start to make your product. And on your product, you can mark as patent pending, which is good. Even you don't have patent yet, but you already had the application in the patent office. And also this provisional application is not going to be disclosed by USPTO. Nobody knows what in your patent, but you can put down patent pending. And also protect against the public disclosure. As I mentioned before you apply for patent, you should not go to conference to present your ideas. You should not to publish in your books or in your articles, right? However, after you have a provisional application, you can go to public to disclose information. You can talk to anybody about this because you already get protection at USPTO. Okay, next screen. Okay, so before we talk more, let's talk about how can we turn our invention idea into a patent. Number one, you must keep all your documentation, your stuff from day one, because this very often after you have patent, somebody may challenge you, say that you copied somebody's idea. Actually, if you have your from original documentation kept, so when you have a litigation, you can show to them from day one. You can make the wonderful notes we call blue books to keep all your documentation, establish your right. to show that you are the first one come up with this good idea. Okay, also you need to do the patent search, very important, because you want to make sure your idea is one of a kind. Okay, so this patent search, today we don't have enough time to show you how to patent search, but we can always talking about later. We have another class to talk about how to do patent search. Okay, and also need to make sure that your invention solve a problem in the market. Okay, so you need to do a thorough market study, very important, because you apply for patent is not for honor, put on the wall, you have honor of you have a patent owner, but you need to find out if your patent can make the profit from them. So you need to do a thorough market study. Okay, you also probably need to make a prototype, even you don't need to do it, but you need to make sure it's not only working on paper, is in the future will be functional for your invention. Then if you go through all this process, you are ready for application to file for a patent. This is about the process. Okay, so we have 7 tips to let you know that how protect your rights. Okay, number 1, we have to say again and again, do not publicly disclose your information. Okay, if you want to talk to anybody, if you want to talk to a lawyer even, you need to sign a confidential agreement. So in the next screen, we will show you what we do with that agreement. Okay, and also number 2, very important, even though in future you get a patent from your invention, but don't forget, your invention must be probably is based on previous invention, a previous patent. So while you're doing your product, don't forget, you need to also pay for the previous patent in terms of licensing fee, because your invention is based on that invention or based on that patent. Okay, and also when you talk to your lawyer, because majority time patent application is done by the attorney, right? Because they are the best one to do the claims, because they can use fancy language and the best language to get your protection as large as possible. So you need to let your attorney or lawyer to know about your pre-art, which is you did your patent search, you find related patent in the past. Okay, so all of this you need to fully understand, agree, you sign about ownership of your invention. If you go to another company, or you switch between employment, right? And you also need to do a search before adopting a name, a trademarks, slogan for your business. Also, again, that's another issue about trademarks, and that's something we also state marks. We are not talking today, right? So this is all the good tips for you to do. Okay, sometimes you also need to concern, should I do patent or should I do about trade secret? That is very important. A lot of things, if you disclose in the patent documentation, it's easy for others to copy. If you get the trade secrets, maybe you get more protection. Okay, so again, all the development, the process, you need to keep all your information. Next slides.
Dan, you can speak about the confidentiality.
Hi, Connie. Sorry, I was on mute again, of course.
Okay.
So you have an example here. Connie talked about the importance of not disclosing your invention. And I want to stress that again, because you can lose significant rights to your intellectual property by having what's called a public disclosure. And that public disclosure is, I mean, Connie talked about going to a, publishing a paper or going to a conference. That's all clearly public disclosures. But even speaking to somebody on the side, right, going to your colleague at a different university and saying, hey, I have this idea and this is what it is, that is considered a public disclosure. A public disclosure is a disclosure of enabling information to anybody that is not bound by confidentiality. So if you want to collaborate with somebody, if you want to run your idea by somebody, you really should have a confidentiality agreement in place before you do so. Now, if we talked earlier today about what's university owned and what's not university owned. If it's owned by the university, you should run it through the university process, the office for research, either us through Innovation Ventures or university research contracts through RAPS. You can come and talk to us at our office, and we'll tell you what the right place to go is. Because in that case, your invention is owned by the university, and the university has to be the one that signs that agreement. If it's owned by you personally, either because you're not associated with the university or you're a student, as Dunbar talked about earlier, we have here a sample of a very simple confidentiality agreement that you can use. But it's really, really very important because especially if your idea is valuable, you can really put yourself at risk by speaking about it publicly too soon. Go to the next slide, please, Mark. The other thing I wanted to talk about, Connie talked about this question of infringing on other patents, and it's what we call the freedom to operate issue. And as you get to these ideas of inventions that are improvements upon others, it really becomes, from a commercialization perspective, a very important thing to look at. So we have here an example that it's simplistic, but it tries to get at that concept, right? So you invent a folding knife, right? It's really cool, and you can, it's like a switch. You can flick it. Maybe it has some automatic retraction. This great mechanism for opening and closing the knife, and you get a patent on that, and you're really happy, and you want to try to go sell it. But somebody else actually invented the actual knife and has a patent on the knife. Now you're in an interesting situation there. So that person that invented the knife, they can sell their straight knives. They can't sell your folding knife, right? Because you have a patent on the folding knife. But since your knife, they have a patent on a knife that has a blade with a sharp end on it. You are infringing upon their knife patent. So you cannot sell your folding knife unless you get permission from that owner, from that inventor. And that's called a freedom to operate mechanism or concern, which is a bit different from the prior art that we talked about before about getting a patent, right? So here there was no one else before had invented the folding mechanism. But you do have a freedom to operate issue. There are various ways you can try to get around that. You can sell an add-on. So we're gonna get somebody else's knife, and we're gonna sell a kit that just does the folding because you're not actually selling the knife. But that's something to think about as you think about the commercialization aspect and the commercialization potential of your invention.
Great.
Connie?
Next slide. Okay, so because we don't have enough time, I just want to let you know that USPTO's website, you can find a process for obtaining a utility patent. As I mentioned, majority patent is a utility patent. So you can always go to www.uspto.gov and to get this information. They have a tremendous documentation about how to obtaining a utility patent. Next slide. Okay, so we are going to be almost end our talk, but something very important about importance of a pre-art search, which is called patent search. Because as I mentioned before that, US patent granted are effective only within United States. Okay, this is very important. You get US patent and were protected in the United States. However, somebody from China, from Japan, if they want to use your idea to make the same thing and sell in Japan or China, which is not infringe your idea, your invention, because you only get United States patent. You didn't get the Japanese patent. You didn't get the Chinese patents. So that's why if you want to get fully coverage, then you need to go through WIPO PCT application. But which means that unless they make something and import it to the United States, then you get your protection. However, when we're doing the patent search, because pre-art search is kind of a term used by patent examiners, and then it's about patent search. When you do patent search, are required worldwide. Even your invention is going to be used in the United States. However, if somebody in Africa already have this invention published in their publications or in the patent, you cannot get your patent in the United States. Okay, so that's why the patent search become very important because required worldwide. Next one. Here is the slide I want to share with you is that when we should do a patent search. Actually, this is also from research to a patent because I divide into 3 parts: formation, how from research to a patent, implementation, how we can make the patent to work in terms of make profit or to do something, and protection, right? Very quick. Before you start your research topic, you need to do a patent search because somebody maybe already done your research before. You don't want to waste your time to do research, right? If you done your patent, you can see the 7 lines here I put here. This is all the area you need to do your patent search, right? So after you done patent search, you make sure nobody have done your research, then you can start your research. Then after your research, maybe you come up with invention. Okay, when you come up with invention, you need to consider, I want to do a patent application. But don't forget, from research to invention, probably already take about 2 years. During these 2 years, you want to make sure that nobody also did your invention before, even applied for patent. So you need to do a search again. So to make sure if you want to do patent application. So when you consider patent application, you also need to consider you want to do patent application, or you want to do trade secret, or you want to do PCT application. According to patent law, after you send in your application, 18 months from the date, USPTO and the entire patent office in other countries will automatically publish your publication, which we call 18-month publication. Your application will be published. Okay, so then you go through examination period time. Eventually you get your grant, your patent. After you get a patent, you are not stop there. You need to go to implementation, right? So here, because too many things involved, for companies, the purpose to get patent is for their own use, for improvement, okay? And for some company like IBM, is for defensive patent. And then they hire a lot of people to do the patent, but they don't actually manufacture anything. But they just want to waiting for anybody want to use their technology, they have to pay them to get their patent. And also, for example, between Samsung and also iPhone, Apple, they also have defensive patent to protect each other, not by others to steal their ideas. But for a lot of things like in universities and for a lot of small inventors, they're trying to do the patent licensing. In this way that they can get that patent to be make profit from patent, right? And then protection. And after you get the patent, it doesn't mean that you have the right for 20 years or for 14 years. You have to pay annuity, which is a maintenance fee. And for utility patent, and in like 3.5 years, 7.5 years, 11.5 years, you need to pay this fee after grant of the patent. If you don't pay the fee, then your patent become public knowledge. Okay, no fees for design and plant. Now, of course, there's a reverse engineering, there's a litigation, so we don't talk more about it. Go to next slide.
Yeah, Connie, so we're running out of time, so maybe we can just put some of these links in the chat, Dan, if you could. Only because we want to give some time. We only have about 2 minutes left, so just
so
maybe
we
I
don't
could.
have time, but I guess Mark said he's going to share this one with everyone. So for all these search steps, whatever, and then as I mentioned before, anybody want to make appointment with me, my last slide has my contact information, right? And example, we don't have time to do it because we need to have a Q&A, and also we have some other things we need to talk about, right? So Connie Wu at Rutgers.edu, and then if you want, if you have invention topics, then you can make an appointment with me. We can do a Zoom consultation, whatever, or one day you need the classes, we always offer workshops about how to do patent search. Okay, Mark, go back to you.
So I do want to open it up to if there's any questions. If you can stay on, then please stay on if you want to ask your questions. So if you want, I guess, raise your hand. Okay. I mean, Connie, I think a lot of people are really kind of mesmerized by what you were saying, because there's really a lot of information people want to know. But I see Thomas has a question here, so I'm going to ask him to unmute.
Okay, what's the question?
Hi, can you hear me?
Yeah, go ahead, Thomas.
Oh, yes,
Hi.
yes.
I have two questions. So thank you very much for the very informative presentation. I really appreciate it. So I have a question. If a provisional patent was filed in 2018 and then there was no follow-up, does that mean it's public knowledge?
No, it's not public knowledge because you applied in the USPTO, the documentation totally just destroyed. Nobody knows.
I see.
Because
Well, I mean,
you didn't disclose to any public, right? It is in the USPTO. USPTO is the only place knows about provisional application. They never look at. But after 1 year, you didn't apply for non-provisional, that become a dispute.
So yeah, this is not my patent. It's more just because I'm involved with people who have this patent, and we've on our papers have disclosed at the bottom
patent,
of it.
your application, not patent. Don't use patent. It's just application.
Application. It's the application.
Right.
So it's not.
Right.
So that the fact that the provisional patent exists has been disclosed in papers. Is that as sort of a conflict of interest? Is that an issue?
Okay, of course, because if this 1 year, because to be honest, I should not provide legal advice, right? But anyway, I want to say that if you already 1 year, you didn't take action to get a non-provisional application, so it is no longer get the protection. So when you decide, say, okay, nobody knows, I'm going to go do the non-provisional application, and the examiners will use your presentation, whatever your paper, used against as a novelty issue.
Okay. Thank you for the information.
Because yourself become evidence against your novelty.
Understood. And the second question I have is understanding sort of the limits for staff at Rutgers in terms of what they can apply. I guess the thing is to what extent are we considered affiliated if we have some sort of other idea that's outside of our research, right? So if we came up with something that's not directly related to our research, but we are associated with Rutgers, but we want to file a patent. If we file it through Rutgers, obviously there's going to be, some owner, the intellectual property is going to be owned by Rutgers, but if we file it ourselves, is there some sort of issue there?
Yeah, so I'll take that
That is
one.
the best person to answer that. Right?
Okay, good, thanks.
I'll take that one. And the answer, as usual, is it depends. It's somewhat fact specific. So generally, let's say you're I don't know, a doctor, right, doing research in the medical school, and you invent a better way to crack peanuts, right? That's completely different, right? Then Rutgers would not claim any ownership. I'm assuming what you're talking about is in the gray area.
Mm-hmm.
It's not quite that that different. That it's somewhat related to what your research was done, kind of what you're doing in the university. So what I would suggest you do is disclose it to us so that we could take a look at the specifics and tell you what we think. So in our office, we're not looking to extend ownership or extend our grasp for things that by by policy we shouldn't get. So that's what my best advice to you is, kind of tell us the details so we can tell you what we think.
Got it. Thank you.
Okay, before we take the next questions, I realize we're running out of time. I do want to share the upcoming events. So we do have, we do have an upcoming event on Wednesday, June 16th. It's from the Tech Advance and Health Advance Road to Commercialization Symposium series. So if you are a faculty, staff, or a student researcher at Rutgers, and want to learn more about, licensing versus a startup considerations, listen to Greg Ehrman and Dr. Victor Jin about the innovations that they developed. So I think Dan will put the link in the chat, and a little bit more about the USPTO trainings in the fall. It's still kind of in the planning stages, but these will be the 4 topics about patent basics, filing a provisional, patenting apps and software applications, and how to conduct the prior art search, which we didn't have time for today. So stay tuned for that, and we'll share that when we have more information about it available. Okay, so we can go back to, thank you all for joining us today. We can go to our next question.
There's a question mark in here. There's another question here in the chat.
Okay, let me,
I'm just answering it.
let me go to Thomas, if you could, Thomas.
Hi, how are you?
Good.
Yeah, so my question is, actually, I think it kind of goes along with the question that's in the chat. But so first of all, if you file patent through Rutgers versus like by yourself, like what kind of the advantages are and disadvantages are, and like what percent of like Rutgers, like let's say like you get a patent and you make a profitable business out of it, like how much percentage of profit would like Rutgers take because of intellectual property rights?
Let me tell you the way describe a little bit better the way this should work. So whether the property is owned by Rutgers or owned by you individually, and whether you have to kind of file through Rutgers, is really set by policy, right? That's the policy we talked very briefly about earlier, and we can go into some more detail about that. So if it's done as, if you're a staff of Rutgers and you're doing it as part of your employment, if you're doing a PhD dissertation, if you're doing it as work in the lab for some professor, then it's owned by Rutgers.
Yeah.
And you have to file it through Rutgers. If it's a student owned, then you have a decision, and Rutgers has a decision, right? You can decide whether you want to do it yourself. Rutgers has no claim on it, or you can bring it to Rutgers and say, Rutgers, would you please handle this for me? Then we would, our office would decide whether we want to or not. At that point, the decision as to whether you should or shouldn't, the plus side of doing it through Rutgers is that Rutgers pays all the patent expenses, right? If it's assigned to Rutgers, Rutgers is paying all the expenses associated with prosecuting the patent, and kind of talked about what that can be. To prosecute a patent fully in the US can easily be $30,000 to $50,000. If you start looking for international coverage, it's multiples of that. So it can be a pretty expensive process. So that's the advantage.
Yeah, because I talked to a lawyer like about getting a utility patent, and he was telling me like it's around $10,000.
I can tell you that we spend more. It depends a lot on how broad the patent is, and what you're trying to get, and what the prior art looks like. It's highly dependent on what the prosecution history is going to be, and how many back and forths you have with the examiner. So there are some that can be for $10,000, and I can tell you there are some that are more than 50.
Okay, so your answer pretty much is like it depends.
It depends, right? And that's you'll hear that a lot anytime you talk about it in any legal realm.
Mm-hmm.
Is it depends, and you never know up front. But my advice to you, right, is if it's all student owned, and you want to do a startup for it, right, and Rutgers has no claim to the patent, why do it through Rutgers?
Because they pay for it.
Because they pay for it, right? That's the only reason. Now, in terms of what goes back to the inventor, right? So the Rutgers presumably is going to license your invention to somebody, hopefully anyway, right?
Mm-hmm.
If it's successful, and as part of that license, we're going to get some license fees, and we're going to get some royalties down the road as it gets commercialized and developed.
Mm-hmm.
Of that, something around 30%. It's a little complex. I don't want to go into all the details, all the nuances of exactly how it is. Something around the 30% area ends up going back to the inventor, and the rest goes to the school, to Rutgers. Some of it goes to the inventor's school or department. Some of it goes to our office to pay for us. But that's basically what, as an inventor, you get back. And that's true whether it's a student IP or faculty IP, with right? So if it's Rutgers owned, that's what the inventor is going to be getting back.
And is that true? Like if I'm using like Rutgers resources, like I don't know, an aluminum 3D printer?
So probably not.
Mhm.
Probably not. The way and I don't know, Mark, if you want to pull up the student IP policy.
Well, so
I saw it was just like
Right.
would-
So
let me-
if it's something that's generally available to students, then we would not be claiming ownership, right? So, Dunbar talked about, if it's in the makerspace, right? Again, we're not looking to, to grab everything, right? That's not the point.
Right. So Dan, though, there might be different kinds of 3D printers, some of them more research grade equipment that would
That's true.
research lab that would be Rutgers claimed, but things that are in a makerspace that are generally available to all would be safe. They would be student owned. So really, again, it depends. Sadly.
That's right.
all right. All right. Yeah, I'll keep your contact info saved.
Right.
So if I want to
So-
reach out.
Right.
Let
And
me-
that's really the best answer, right? Reach out to us and we'll talk you through the details.
Let
Awesome.
me
Thank you.
let me add a layer to this, because for the ideas that are filed into the Rutgers system, they go through an evaluation process. Not every idea is patented. So the budget is only so big, and there's a decision made, and many ideas are not patented. So there's no certainty that if you file it through Rutgers, that Rutgers would choose to patent it. So that would be, again, evaluated by the committee that does that.
Yeah. By the way, thank you for this presentation. It was very informative.
Great, thank you, Thomas.
Thank you,
And
Thomas.
now, Stephen? Any other questions you could also put in the chat while you wait for your time to ask your question, but go ahead, Stephen.
Yes, I have a question regarding coding. If you were hired as a student researcher or like a faculty and you create something, and then let's say you're no longer hired, but you have maybe a better version or an extension to that, would you have to go back to like Rutgers and ask for permission? Or if it's an extension, would you just be able to release it as is?
All right, so I guess that'll probably be for me too. If there's a concept under copyright called derivative work, right? So the work that you did while you were hired is owned by Rutgers. If you make a derivative work, meaning you take that and you extend it, it becomes kind of like that example I had with a knife, right? So Rutgers doesn't have any claim to the new stuff you did, but Rutgers does have a claim to the old stuff. So you would have to, technically you'd have to get permission from Rutgers to use the old stuff in your new stuff. Does that make sense, Stephen?
Yes, follow-up question.
Yeah, go
What
ahead.
if there was one way to do something and you did it while, under Rutgers, and you want to continue that thing after you're finished hired or something? If there's no other way to do it, like an idea or a certain procedure, do you just still have to go back to Rutgers or what?
Yeah, again, it's getting to very fact specific. There are kind of exceptions to copyright law. Exactly say there's only one way to do it. So it's very fact specific. But the other thing we're going to look at, right, if you come to our office with that kind of question is, what's the commercial value, and what's the academic value, and if it's certainly possible that we would say we have no problem with you using it, right? Again, we're in a university. We know we're in a university. We're in the interest of getting the work out and into the world. So what I would tell you is kind of come talk to us, because these questions are very fact specific. There's no generic answer. It depends on the details.
Okay,
Okay,
Thank you.
great. Okay, great. So there's a question here by Nicholas. If a previous patent later becomes identified as offensive against public morality, what happens to the patent? So I don't know.
Okay, I can see a little bit about it. Is that during the patent process, even after issued by USPTO, and a patent still get at least 3 months for public to look at, to challenge the patent. So very often, if it's at the beginning stage, like 3 months after the issued patent, all the competitors, everybody can challenge the patent about novelty, about everything based on those 3 tests. But later on, as the question asked, few years after, and then realize that that particular patent become offensive. And then you also can write to the USPTO, about your concerns, whatever. And then there will be higher level, I guess, examination, whatever committee, whatever something will look at. I think public always can raise their voice, talk to the USPTO.
Okay, great. Thank you, Connie. And there was a question also in the chat I missed earlier. Oh, I think Dan is answering it about who the first point of contact is to contact at Rutgers for discussing and filing a patent. And
Right. So really, our office is the place to do that. You can either call us or you can submit a disclosure of the invention. Now I was actually just looking. I see Dunbar actually posted, or Mark did, posted a link for that. So that's really the best thing to do. So the best thing to do is to submit a disclosure to us. That disclosure form includes details about the invention. So when we get on the phone with you, we can, we already know something about what you're talking about. You can send us any papers or anything to look at to inform that discussion, but that's really the best way to do it. If you want to talk in general about kind of what is or is not patentable, especially at the beginning of your research, and we encourage you, right, as you begin, if you're beginning to think about research, to come and talk to us with thinking about having a practical invention at the end point. That would be great. And just email us. You can email me and I'll put you in touch with the right person in our office, or all our contact information is on our website.
Oh, and one other thing I wanted to add, I forgot, I wanted to mention earlier, I didn't want to interrupt, is that when you file the provisional patent, you've got that 1 year. And so I think they do it a lot in other I-Corps sites. That 1 year is a good time to actually apply for I-Corps and to consider the commercial application, commercial potential of the application, because then you can actually make a business decision about whether it's quote unquote worth it to file for the full patent. Because if you find out that there's no market need that you thought that you originally thought there was, then there's no need to kind of submit and pay all the money for that patent. But if you within that year discover through customer discovery and going through I-Corps, you realize, hey, this is a really big problem out there and people need this type of solution, and they're willing to spend a lot of money for your solution, then it's like, okay, this is a business decision. We are creating value in the market. Let's put some investment in the patent because we know there's going to be a return on it later. So it's something to consider for the people who are, filing or have already filed for a provisional patent. So it's something to consider.
One thing I like to add to that is that I think would be wonderful for students to get patent before even you graduate, because it's good for your job market. We had a student at School of Engineering got patents, and they told me that they got easy to get jobs, because very few students before even undergraduate student has a patent. When they have patent, no matter it's useful or not, in many times people will consider you are creative in many ways. So it would be wonderful for students to get patents during the school year.
Great. And so, we're well over time and we recognize that. So I want to just thank our panelists today. Thank you, Connie. Thank you, Dunbar and Dan. Really great information. I know people might still have questions, but I do want to give a chance for those who have to drop to go ahead. But thank you so much for this important information. Feel free to join us in our next virtual event sponsored by I-Corps at Rutgers. The deadline for I-Corps is June 4th. So if you have questions, you can email me, Mark at m.deguzman@Rutgers. But if there's any other questions, we can continue to take them. But I just wanted to officially close the meeting.
Hey, Mark, we should also put a plug into Connie's patent sessions next in the fall.
Yes,
Yes.
already
Yeah.
mentioned, right?
Yeah, I mentioned earlier briefly, but we'll, stay tuned. So as we have more information, we'll send it out.
Great. Thank you all. Thank you so much for organizing this wonderful event, Mark.
Yeah,
Thank you,
yes.
Connie.
Thank you, Connie.
Thank you, everyone.
Okay, wonderful.
I'll-
Thank you all. Okay.